Hello, everyone. This is Sharon Smoot with eXp Realty, and I am here with episode, I believe, 12. Let me check and see. I think it's episode 12. Let's see. Let me turn my volume down on the phone. Oh, goodness. Let's see. I should have checked this before I started. We are on, episode 12 of Realtor Life with Donell and Sharon. And as you can see, there is no Donell tonight. He texted me a little while ago and said he had a headache, wasn't feeling well, and that he was going to take some Tylenol and try to hop on. So I'm not sure if he's going to be on or not. So I'm having to pivot. We were going to talk about the due diligence period tonight, but since I do not have my partner here, I think that I am just going to pivot and discuss representing sellers in short sales, divorce, bankruptcy, and probate. Okay. And my suggestion, if you're going to handle short sales, is that you go through a short sale certification course. So I'm going to start with short sales and just give you an overview of what you need to know. But the information that I'm sharing with you tonight is not a substitute for a short sale certification class. I went through the short sale and foreclosures certification a number of years ago. It is an excellent training. The designation is SFR, Short Sale and Foreclosure Resource. So what you need to know about representing a seller in a short sale. Number one, they do not have to be behind on their mortgage payments presently. However, they have to have a looming hardship that will make it difficult or impossible for them to make their mortgage payments. That's the first thing you need to know. They have to have some type of financial hardship that is going to prevent them from making their mortgage payments. So that can be the loss of a job, a reduction in income, what I would call underemployment. It can be the death of a spouse or co-borrower. It could be a medical issue, anything that's going to impact their finances in such a way that they'll be unable to make their mortgage payments. But they don't have to already be in the midst of that hardship. If they know that it's coming, say, for instance, that they found out that they have cancer, and they're going to have to go through an extended treatment for cancer that's going to impact their ability to work. That would be considered an impending financial hardship. And, divorce, anything that impacts the finances is a financial hardship. The second thing that you need to know about doing a short sale is that they have to be underwater. So in this market, at least here in Atlanta, home prices have skyrocketed. So the chances of a whole lot of people needing to do a short sale like back during the Great Recession is very, very unlikely. But you may come across someone who maybe has refinanced multiple times and taken out all the equity in their home and fallen behind on their mortgage payments, and they need to do a short sale. So it's not beyond the realm of possibility. I just don't anticipate that we're going to have that flood of short sales like we did during the Great Recession. So financial hardship, and they have to be underwater. Anyone who wants to do a short sale needs to be prepared for their finances to be delved through. And the reason that I mention that is that I actually had a client during the Great Recession who wanted to do a short sale, but he had no paperwork. This person did not keep bank statements. He did not keep pay stubs. He didn't keep his tax returns. He didn't have anything. And when I told him that he was going to have to gather up all that stuff, go to his employer to get his W-2s, contact the IRS to get a copy of his income tax return, or go to the person who prepared his taxes, whatever, get his bank statements from his bank, he put up such a stink that I ended up terminating the listing. And it was really a lesson to me to get as much of that information on the front end before you even put the property in the multiple listing service. If they are unwilling to provide you with the documentation necessary to effectuate the review by their bank, there's no point in even listing it. So, what paperwork are they going to need? They're going to need bank statements and who knows what the banks will want these days. I don't know how much of the requirements have changed since the Great Recession, but I think when I was working with this gentleman, that this particular lender wanted like 6 months worth of bank statements. They're going to want at least 2 months worth of pay stubs. They're going to want the 2 most recent years income tax returns and W-2s, and any other documentation to support the financial hardship. So if it's a situation where maybe a spouse or co-borrower has died, they may want a copy of the death certificate. But you need all of that information. You'll need to get an authorization signed by the customer for the mortgage company to communicate with you. And they will have some affidavits and things like that that the seller needs to complete. And most lenders have those documents available on their websites, and you just have to download them, give them to your client to complete, and then you can submit everything. Hello, everyone. I am flying solo tonight because my business partner, Donell, isn't feeling well. But thank you for tuning in. And if you have any questions, just post them in the comments, and I'll be more than happy to answer them for you, okay? So, what else do you need to know about representing someone in a short sale? Hey, Tiffany, how are you? I hope you're doing well. So let's see. Talked about the paperwork, timetable. A short sale can take, I'd say, as little as 30 days. I think the longest one that I ever had took about a year and 2 months or so. So it is a time-consuming process because the mortgage company is going to comb through the seller's finances to ascertain whether they actually have a financial hardship. And other pieces of information that you need to provide. If there is a homeowners association, you need to find out if the dues are current or not. And some sellers will know that they're behind on their dues, and they'll have an idea of how much they owe. Others will not. So you might have to do a little bit of legwork and reach out to the HOAs to find out. Another thing that you need to know is whether the property taxes are current. And 9 times out of 10, if the mortgage payments aren't being made, then there might be a delinquency on the property taxes as well. And you can contact the county, really just go online for the county where the property is located, and you can see whether there are any delinquent taxes. Now, the reason that you need to have this information is that when you submit the short sale package, and that's the document or the package that has all of the buyer's supporting documentation, their bank statements, pay stubs, et cetera, you're also going to have to submit a preliminary settlement statement or a preliminary closing disclosure. And that document is going to be used by the lender to ascertain how much money they stand to get out of the deal if they approve the short sale. So it is imperative that those numbers be as close to accurate as possible. And it's really important that you have a good and cooperative closing attorney on deck who can help you out. I have, in my experience, dealt with some closing attorneys who are better than others. And a lot of the times what happens, especially if the purchaser is an investor, is that they have a closing attorney that they want to close with. And unfortunately, the investor's closing attorney might not be as well versed in handling short sales, might be a little bit uncooperative. So let me give you an example. Back during the Great Recession, I had a short sale down in South Fulton. And my client lived in California, and she told me that her taxes were delinquent and that she owed HOA dues, but she wasn't quite sure how much. So I reached out to this closing attorney, and it was a closing attorney that was already on my list of closing attorneys that I don't like doing business with. And the buyer was an investor, insisted on using this particular law firm. I asked them if they would do a preliminary HUD, and they said, sure. They sent it over to me. It didn't have any information on it. And I'm like, okay, what am I supposed to do with this? And they said, well, we don't pull title until after the short sale has been approved. And I was like, what the, you know what? How does that help me? How does that help me? Because the numbers have to be as close to accurate as possible. So if you submit a preliminary HUD to the lender and they do everything that they need to do to review this and they approve it, and then title gets run after the fact, and come to find out the HOA dues are delinquent $3,500, but you didn't account for that on the preliminary HUD, guess what? They're not changing that preliminary HUD. And so somehow those HOA dues are going to have to be paid. And guess who's probably going to end up paying them? You, out of your commission. So it is imperative that those numbers be as close to accurate as possible. So in that situation, what I ended up doing was just overestimating. I think I estimated that she owed, based on what I could see on the tax records, I think I estimated that she owed like $5,000 in delinquent property taxes and $7,500 in delinquent HOA dues. And I had reached out to the HOA, and they wanted me to pay for a closing statement up front. And I wasn't willing to do that. I'm not going to pay for a closing statement. So, I had to estimate. And thankfully, I had overestimated. So the bank ended up actually netting more money than they thought they would once title was run. So it's just imperative that you have as much information as you possibly can. And I recently heard a story about a young lady who had done a short sale, didn't know what she was doing. And when everything was said and done, those numbers did not work out correctly, and there was no money left to pay a real estate commission. So neither she nor the selling broker, her broker nor the selling broker, got a commission. And she was just at a loss for how that could happen. Well, it happened because she didn't know what the heck she was doing. And when she submitted that preliminary HUD, it did not have accurate information on it, upon which the mortgage company could base their review and their final decision. And what happens is that when the short sale gets approved, the lender sends a short sale approval letter, and it breaks down exactly how much money goes toward the property taxes, toward the HOA dues, toward paying the mortgage off and says what the bottom line is. And so that's how a short sale works. And I just cannot emphasize to you enough how important it is that you have those numbers right. And if it's your first short sale, my suggestion to you is that you have a more experienced agent who has handled short sales. You don't want an agent who's been in the business for 15 or 20 years, but never done a short sale. You want an agent who has actually worked a short sale before and got it through to the finish line to assist you and to be there to answer your questions and guide you so that you don't screw up like the young lady that I just mentioned and end up walking away with zero commission. Because after all, commission is how we make our money, right? All right, so that's what you need to know about short sales. And that is just a brief overview. This is not meant to be an exhaustive tutorial training on these topics. So let's talk about representing someone who's going through a divorce. In Georgia, there is something called a standing order. When someone files for divorce, no matter what county they file in, a standing order goes into place. And the verbiage of the standing order might vary a little bit from county to county, but one of the main objectives of the standing order is to prevent either of the parties from disposing of any property, real or personal, during the pendency of the divorce. So the standing order may or may not prevent someone from trying to dispose of property. However, if they do, they can be penalized by the court. Now, a possible remedy, you would think, would be for the court to reverse the sale. Let's just say that Tom and Mary are in the midst of a divorce. The standing order is in place, but Tom sells a piece of real estate out from under Mary, unbeknownst to her. The court is more likely than not going to force that buyer to return the property to Tom and Mary because the standing order does not put the world on notice that the property is the subject of a divorce. So, what do attorneys typically do when they file a divorce complaint and there is real estate at issue in the divorce? They will also file a document called a lis pendens. That document gets filed in the real estate records. And the lis pendens, it's two words, LIS, PENDES. DENS, I'm sorry, lis pendens. And it tells the world that this particular property, identified by address and legal description, is the subject of a divorce proceeding. So when the closing attorney runs title and they see that lis pendens, they say, hey, we can't move forward because this property is the subject of a divorce proceeding. So it puts the world on notice that there's a divorce pending. So in the example that I gave you, if Tom is trying to sell the property out from under Mary and Mary's attorney has filed the lis pendens, that closing attorney is going to put a halt to closing that transaction until there is a court order in hand authorizing the sale of the property. So I have a friend, one of my attorney friends, and for those of you who don't know, I practiced law for about 14 years, including real estate law, family law, bankruptcy, and a little bit of wills and probate. So that's why I feel like I'm qualified to talk to you about some of these topics tonight. But I was talking to a friend of mine a couple weeks ago, and she was, just asking me for some tips on how she should handle a particular matter. She has a client, and she and her husband are in the process of a divorce. but she is dead set that it's going to be an uncontested divorce. So, despite my friend's advice, her legal advice to go ahead and file so that she could have this Liz pendants recorded in the real estate records, her client said, no, I want him to sign first before we do anything. Only to find out one day when she gets home from work, everything's been moved out of the house, and the husband announces to her that he has sold the house. He has purchased another home using the proceeds from the sale, and that she needs to figure out where to go because they need to be out of that house. All the furniture gone, everything. So if she had allowed my friend to go ahead and file the petition for divorce, that Liz pendants would have been in place and it would have protected her. So when you are meeting with someone, a seller, and they tell you that they're in the middle of a divorce or they're contemplating divorce, there are some key questions that you need to ask. Number one, has the petition for divorce been filed? Number two, who's your divorce attorney? And will you give me authorization to speak with your divorce attorney? Number three, whose name is on title? And that can be really sticky because just because a property is titled in only one spouse's name doesn't mean that the other spouse doesn't have a marital or equitable interest in the property. And this is really getting into the weeds, getting into some real technical legal stuff, but it's information that you need to know. So you also need to find out if there is any type of settlement agreement, because the parties can still be going through the divorce, but they could have entered into a settlement agreement as it pertains to a division of property. And maybe they're still fighting it out over, child support or alimony or things like that. So any documentation that they have that outlines how any real estate or other assets are supposed to be divided, you need to see a copy of that. And the closing attorney is going to want to see those things as well. So get those documents up front, and you want complete documents. You don't want just a page pulled out of it. You want, if it's a 12-page document, you want all 12 pages. And some people might feel funny. They don't want you to know all their personal business, blah, 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 blah. But the closing attorney is going to need that information, and it's best that you get it on the front end so that you know exactly what you're dealing with. I'll give you an example that happened to me. Earlier in the year, I listed a property. The parties were already divorced. And my client was the wife, the ex-wife. And the husband, ex-husband, was most uncooperative initially. And I just tried to kill him with kindness. Please, thank you. I really appreciate it. Thank you so much. You're great. I'm really enjoying working with you. Just really trying to kill the guy with kindness. And he seemed to, kind of let his guard down and began to trust me. We never met in person. I think we may have had one phone conversation. Most of our dealings were via text or email. But the wife sent me the order granting the divorce. And she sent me, I can't remember, she sent me another document, but it wasn't the final judgment and decree. I can't remember exactly what it was, but when I finally saw the final judgment and decree, I was like, damn it, I have gone through so much dealing with this man and I didn't even have to. Because what the final judgment and decree said was that he had already quitclaimed his interest in the property to her. And I can't remember if it was his attorney or her attorney was holding that quitclaim deed until she paid him X number of dollars. So if I had known that there was a quitclaim deed in play and I had just gotten a copy of it, I could have gone ahead and listed the property without securing his signature on all of the listing documents because he had already quitclaimed to her. It just hadn't been recorded yet. The final judgment and decree said that it would be recorded after he received whatever amount of money he was due pursuant to the terms of the decree. So it's just important that you know exactly what you're dealing with and that you have all of your ducks in a row when you're dealing with parties who go through divorce, and you've got to be prepared to deal with conflict because 9 times out of 10, somebody is still pissed off and they're going to try to make things difficult just for the sake of making things difficult. Like with this guy, he stood to get a lump sum of cash. And so in my mind, I'm like, why is he being so difficult when this will benefit him? He's going to walk away with, I think it was like $16,000 or so, give or take. Why is he being so difficult? Doesn't he want this money? And I think he just kind of got a kick out of, making things difficult and causing his ex-wife, some consternation and upset. But anyway, I just say all that to say, when you're representing people that are going through a divorce, you have to be very, very sensitive. And the thing about it is that, there can only be one realtor or brokerage as the listing broker. So it's not like he has an opportunity to choose his realtor and the wife has an opportunity to choose her realtor. There's going to be one brokerage, and you don't want one party to feel like you're taking the other person's side. So you've got to be in constant communication with both. Don't tell one thing without telling the other the exact same thing. Don't tell one thing to one of them and tell the other one something completely different. I mean, you've got to just be very cognizant of the fact that you don't want to be the source of the conflict. You want to make sure that you are being open and communicative, equally communicative with each of those spouses so that they feel like you are advocating for each of them and trying to help each of them rather than trying to help one or the other. And in all honesty, because the wife in this example that I gave you, she's the one who contacted me. We had the initial meeting at the house. I always felt like she was my client and that he was just, trouble being dragged along the way. But I did, like I say, try to kill him with kindness and, let him know that I was advocating for him and trying to get the best deal possible so that they could walk away with as much money as possible. And I think at the end of the day, I did accomplish that. He sent me a text message after it closed, just thanking me for being so kind and patient. So it meant a lot to me. So my takeaways for dealing with anyone who's going through a divorce, listing a property that's a part of a divorce. Number 1, know whose names are on title. Number 2, know the status of the divorce. Has the complaint been filed or the petition been filed? Has the judge issued any orders? Get a copy of any orders or settlement agreements that have been approved by the court. Know who each party's divorce attorney is so that if you have to communicate with them, you can. And get written authorization from each of the sellers to communicate with their divorce attorneys in the event that the need to do that arises. Okay, so let's talk about representing someone in a probate. I am going to leave bankruptcy for last. So, first thing you need to know about probate is that there are 2 types of probate. One where the deceased person had a will, one where the deceased person didn't have a will. If someone dies without a will, they are said to have died intestate. If someone dies with a will, they are said to have died testate. So when someone dies with a will, that means that they have set forth their wishes as it pertains to all of their property, how they want it handled. So they might indicate that they want the property to be passed on to the spouse or to the kids or to the grandkids. And maybe that spouse or those kids or those grandkids don't want the house. And they've indicated that to the executor of the will. The deceased person, one of the things that the will does is it sets forth who the executor of the will is. The executor is the person who oversees the estate. Once someone dies, all of their property becomes a part of the estate. That's personal property and real property. Any cars, houses, jewelry, clothing, pets, everything that they own becomes a part of the estate. And the executor is the person who oversees that estate. The will has to be presented to the probate court, and the probate court will issue what is called letters testamentary. So when someone contacts you and tells you that they need to sell a piece of property, that the owner is dead, and that they're the executor of the estate, the first thing that you want to know is, do they have letters testamentary? Letters testamentary is the authorization from the court for them to begin managing and disposing, distributing the property of the estate according to the terms set forth in the will. So if they have the letters testamentary, you need a copy of that, because when you list the property, they're not going to sign in their individual name, and they're not going to sign in the deceased person's name. They're going to sign as Mary Smith, as executor of the estate of John Smith. So that's important. You need to have those letters testamentary. And when you turn in the listing agreement to your broker, you're going to include a copy of the letters testamentary. Now, the other thing that you need to know is that sometimes, depending on what the situation is, the probate court may require the executor of the estate to post a bond. The letters testamentary will also set forth the powers that the executor has. And sometimes those letters testamentary will say that the executor has to get authorization from the probate court to do certain things. So don't just grab those letters testamentary and not look at them. You need to read them and make sure that you understand what actions the executor can and cannot take. And a lot of the times in the will, it will say that the executor is not required to post a bond and shall have all the powers set forth in the appropriate code section. And I can't quote you the code section. I've forgotten all of that stuff. But anyway, so once you have those letters testamentary, you can go ahead and list the property. And, let me backtrack to the divorce. If the home goes under contract and the divorce is still pending, and the court is going to have to approve the sale, you need to make sure that the contract says that the sale is contingent upon approval of the Superior Court judge in the case style Smith versus Smith, case number, blah, 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 blah. With the probate cases, if the letters testamentary say that the executor has all the powers, then you don't have to worry about including any language stating that the transaction is contingent upon approval of the probate court. However, if the letters testamentary indicate that probate court approval is required, any purchase and sale agreement needs to contain a special stipulation that says that the sale is contingent upon approval of the probate court in probate case number, style the estate of, John Smith, case number, blah, 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 blah. So the closing attorney is going to want to see a copy of the letters testamentary. They may also want to see a copy of the will. So you need to be prepared to provide those documents to the closing attorney. Now, if someone dies without a will, the person who oversees their estate is called the administrator. And someone has to apply to the probate court to be the administrator of the deceased person's estate. And once the probate court approves that, they're going to issue what's called letters of administration. And those letters of administration may set out that the administrator has all the powers set forth in the particular code section of the laws of the state of Georgia, or whatever state that you're in. And things might be done a little bit differently. I am in Georgia, so I'm always talking about Georgia. But hopefully some of this information will pertain to wherever you are, or at least be a framework to help you figure out how to do it in your state. So anyway, the letters testamentary might say that the administrator does not have all the powers. It might say that he only has specific powers. It might say that he has no powers to do anything without authorization of the probate court. And it might say that he has to get a bond. So let me give you an example. I listed a property, God, I guess that was, I'm trying to think, was that pre-pandemic? Yeah, that was pre-pandemic. So that must have been at the beginning of 2019. And the gentleman's mom had died. He was the administrator of the estate. I got the letters of administration, and they did not give him any powers. He was not going to be able to sell that property without getting authorization of the bankruptcy court. And the closing attorney, this was a really interesting case. The closing attorney is in Tennessee. The closing attorney has an attorney locally that facilitates the signing of all the documents, but doesn't disperse any of the money or any of that. And that closing attorney in Tennessee was making us jump through a whole lot of hoops, because whatever the order was, it said that the guy had to post the bond. So he was trying to get the bond. And, oh, I can't remember all the details of it, but it was like they wanted us to do something first that we couldn't do. And it was something like where they wanted the judge to, the order said something about the judge needed to approve the sale within so many days after it had occurred. But the closing attorney was like, we can't close until the judge has approved the sale. I mean, it was just crazy. Well, when the thing came up about the bond, because initially the judge did not say that my client had to post a bond. When the thing came up about the bond, my client goes to try to get the bond, and the bondsman wanted, I don't know, $5,000, $7,000. And my client didn't have it. He was on disability. So what ended up happening was that the probate court appointed a local attorney, a Clayton County attorney, to act as administrator. So we get all that taken care of, and we finally get to the closing table. But my client, he never was, I think, processing the information that I gave him. And I kept telling him, come to find out, he had a sister. How I found out about the sister was that she called me And she said, I want to be at the closing. I want to make sure I get what's due to me. And so when I called him, I said, somebody called me saying that she was your sister. And he was like, oh yeah, but she signed away everything. She's not getting anything. And I said, wait a minute, what do you mean she signed away everything? Well, she signed the papers with the probate court. And I said, all she did was acknowledge service. Acknowledging service doesn't mean that she's given up any rights that she might have in the property of the estate. Well, I don't see why she needs anything. I lived in the house with my mom. I'm the one who's been taking care of all this. She already has a house, blah, 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 blah. And it's like, okay, let's be clear on one thing. When the transaction closes, they're not writing a check to you as an individual. They're writing a check to the estate. And I'd already told him this because I made sure he knew to open a bank account in the name of the estate, get a tax ID number. So he had done all of that. But it was not computing that he was not going to walk away with a check in his name. So when we got to the closing, he had brought his uncle, and I had already had a phone conversation with the uncle that just went left, and this man stepped all way out of bounds with me. But anyway, I say all of that to say, even at the closing table, he thought that he was going to walk away with a check. He had zero appreciation for the fact that the check was going to be made payable to the estate, and that the closing attorney, not the closing attorney, but the attorney who had been appointed as the administrator of the estate, still had to go through the process with the probate court in order to get authorization to disperse the funds. The same thing that my client would have had to do had he remained administrator of the estate. So it's not necessarily that it's so complicated. It's just that there are certain little intricacies that you have to understand, and each case can be different from the next case. So if you're dealing with the probate situation, you want to know whether the person died with a will or without a will, testate or intestate. You want to know whether the letters of administration or letters testamentary have been issued. You want to know whether the letters of administration or the letters of testamentary, the letters testamentary give the administrator or the executor, whichever the case may be, full powers. And you want to make sure that in either situation, whether it's an administrator or an executor, that they have opened a bank account in the name of the estate and obtained a tax ID number. Because like I said, the check is not going to be cut to individuals. It's going to be cut to the estate. And it's up to the estate to disperse the funds as set forth in the will or authorized by the court. So that's just a little overview on handling probate. So let's talk about bankruptcy. We have about 15 minutes left. A lot of agents think that if someone is in bankruptcy, that they cannot sell their house. And that is 100% false. 100% false. If someone is in a Chapter 7 bankruptcy, I don't think that it is worth your time to list the property. If they are in a Chapter 7 and they want to try to sell the house, my advice would be to wait until the Chapter 7 case has been discharged or dismissed. It really depends on whether, as a part of their Chapter 7, they have agreed to surrender the property. If they're surrendering the property, there's not going to be anything to sell. They've indicated to the bankruptcy court that it's their intention to walk away. So if they are in a Chapter 7 and their goal is to save the house from foreclosure, or stave off of foreclosure, they need to dismiss that Chapter 7 the mortgage company will have to start the foreclosure proceedings all over again. And maybe in the interim, you could get the house sold. Chapter 13 bankruptcy, which is a debt consolidation plan, is what this talk right now is all about. If someone is in a Chapter 13 bankruptcy, they can sell their house. The way Chapter 13 works is that once someone files the petition for bankruptcy, an automatic stay goes into place that prevents their creditors from engaging in any collection efforts. They can't call, they can't write letters, they can't threaten foreclosure, anything like that. The debtor and their bankruptcy attorney draft what is called a Chapter 13 plan. And that Chapter 13 plan has to set forth how all pre-petition debts are going to be paid. So if there is a mortgage arrearage on the date that the bankruptcy petition is filed, that arrearage amount gets included in the Chapter 13 plan, as does any other debts that the debtor has. So when you decide that you want to sell your house and you're in a Chapter 13 bankruptcy, or when a client decides that they want to sell their house and they're in a Chapter 13 bankruptcy, they have to get permission from the bankruptcy court to sell the property, because everything that they own becomes the property of the bankruptcy estate. And essentially, the bankruptcy trustee becomes the equitable owner of the property. So, what do you need to do? You need to get your client, number one, to give you authorization to speak with their bankruptcy attorney. You got to get that in writing and transmit that to the bankruptcy attorney. Number two, when you list the property, you need to make it clear that the property is subject to a bankruptcy and that the sale of the property is contingent upon approval of the bankruptcy court. And that would need to be a special stipulation in any purchase and sale agreement that your client enters into. So once you are under contract, you would need to submit a copy of the listing agreement and the purchase and sale agreement to the bankruptcy attorney, because the bankruptcy attorney is going to have to file what is called a motion for leave to sell with the bankruptcy court. And because you've got to get approval from the bankruptcy court, the closing date needs to be far enough into the future to give those processes a chance to happen. So I'm going to say at least 30 days, better yet, 45 days. And hopefully the bankruptcy attorney will file an emergency motion so that it could be heard sooner rather than later. And what's going to happen is that the bankruptcy court is going to be concerned as to whether or not it's an arm's length transaction. And that is true even of a short sale. A short sale has to be an arm's length transaction. You can't sell it to your cousin. You can't sell it to your girlfriend. It needs to be an arm's length transaction, with no shadiness, no possibility of shadiness. So arm's length transaction, as close to fair market value as possible. And I think that was one thing that I left out when I talked about the short sales too. You need to provide some comps to the mortgage company. But the bankruptcy court is going to look at property values and ascertain whether or not, it's a legit sale for as close to fair market value as possible. If the bankruptcy court grants the motion for leave to sell, the bankruptcy court is going to issue an order, and that order is going to set forth how much of the proceeds of the sale must be turned over to the bankruptcy court. And that means that the closing attorney has to receive a copy of that order. And one of the things that is really interesting about how bankruptcies are handled here in Georgia is that nothing gets filed in the real estate records to put the world on notice that the property is the subject of a bankruptcy. So you have no way of knowing that unless the seller is honest with you. And when I was practicing law, I actually had a situation where some people sold a house. I handled the closing, everything went smoothly. And one day I get a phone call from someone who claimed to be the bankruptcy trustee. And oh, when I tell you, he laid into me because apparently these people had been in a Chapter 13 bankruptcy. They did not disclose it to me, they hadn't disclosed it to their realtor. There were no provisions in the purchase and sale agreement that indicated that the property was the subject of a bankruptcy and that the sale was contingent upon approval of the bankruptcy court. And he was threatening to go to the bar against me. He was threatening to file a lawsuit against me. And the people got a little bit of nothing out of the sale. I mean, they probably got $2,000 or less, not a whole lot of money at all. But he wanted to know how come I hadn't checked the bankruptcy records when I ran title. And I said, well, first off, I don't run title myself. I farm my title work out. I said, and secondly, the title standards in Georgia don't require that the bankruptcy records be checked. I said, so the title examiner didn't check it. I mean, I've never had a title examiner check the bankruptcy records, but he wanted to see a copy of the settlement statement. He wanted to see a copy of the purchase and sale agreement. I mean, and nothing became of it because I hadn't done anything wrong. But when you are consulting with a seller, I think that it is always a good idea to ask them if they're in a bankruptcy, if who owns the property, who are the title holders, because believe it or not, sometimes a co-owner will be dead and the estate hasn't been probated or anything. The person just thinks that they can sell it. And depending on how they hold title, maybe they can. If they hold title as joint tenants with full rights of survivorship, they don't have to probate the will, because when someone dies and they held title as joint tenants with someone else, the dead person's interest in the property automatically conveys over to the other joint tenant. If they held title as tenants in common, that is not the case, and the estate has to be probated. But anyway, back to the bankruptcy. So just make sure that you ask whether they are in a Chapter 13 bankruptcy. And if they are, know that there are just some steps that you need to take. So the moral of the story is that whether it's a short sale, it's a divorce, it's a probate situation, or it's a bankruptcy, there are going to be some additional hoops that everybody has to jump through in order to effectuate the sale of the property. But it can be done. If you are a new agent and you have never handled any of these transactions, I can't emphasize to you enough how important it is that you have a mentor who can guide you through. I'm not telling you that it can't be done. Everybody has to start someplace, but you don't want to dive into one of these more complex transactions and, find yourself in a situation where, you've made a horrible mistake. You're not going to get a commission. Maybe, you're looking at being sued because you made an error or you omitted something, whatever. So just make sure that you have the guidance that you need to get through the transaction successfully. So I think that is it for tonight. I will say this. Donell and I are a part of the legacy team, and our little sub team is called Team Limitless because the possibilities are limitless in this career of real estate. And we are always looking to grow our team. We are looking for hungry, motivated, dedicated realtors. And whether you are new to the business or you have been at it for years, we would love to have you on our team. EXP is an amazing company. And I will tell you that I have been with the same brokerage for whew, over 14 years. Yep, over 14 years when I decided to move over to EXP. And I really don't have anything to say about my other brokerage, anything negative to say about my other brokerage, but I do not regret moving to EXP. I am so happy that I made the move. EXP is an international company. It is present in over 17 countries. I can't even name them all. Canada, Mexico, Spain, Great Britain, Australia, South Africa. Oh, I can't name them all. But anyway, 17 countries, over 59,000 agents strong. And what is so amazing is that we can build our team across the US and across the globe. It doesn't matter where our business partners are located, we can bring them on. And so that is just such an amazing growth opportunity. And EXP offers so many amazing tools. I mean, I thought what I had at my other brokerage was great, but EXP takes it to a different level. And one of the best things about EXP is that it is a cloud-based company. So hear me when I say this, a cloud-based company has been from the day it started over 10 years ago. So when the pandemic hit, EXP didn't have to try to pivot and figure out how are we going to do sales meetings? How are we going to do training? We got to get set up with Zoom so that we can accommodate all our agents, blah, 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 blah. EXP already had all of that figured out, in place, and up and running for 10 plus years. So we didn't miss a beat when the pandemic hit. We were already rolling and grooving, rocking and rolling. And, nothing changed for us. It was just, business as usual. I think that's a great way to put it, business as usual. So that's one great thing about EXP. Well, two great things, the tools and that it's a cloud-based company. EXP also offers revenue share, not profit share, revenue share. So what's the difference between revenue share and profit share? If the company's profit is zero, the share is zero. Revenue share is based on the company's revenue. So as long as the company is making money, no matter how much it is, no matter how little it is, there's something to share. And everybody at EXP is on an 80-20 split until you cap. Once you cap, you're at 100% commission. So that revenue share that I'm talking about, so I am on Donell's team. He brought me into EXP. So every time I have a closing, I get 80%, EXP gets 20%, and Donell gets a revenue share sliced out of that 20% that gets deposited directly into his bank account. He doesn't have to do anything. And he gets a nice little gift whenever I have a closing. So that revenue share is just amazing. And there have been a couple times when he said he's looked at his bank account and been like, wait a minute, what is this? And then he's like, oh yeah, that's right. Sharon had a closing the other day. So revenue share is great. And one day Donell and I are going to do a Realtor Life with Donell and Sharon, where we share the revenue share calculator with you so that you can get an idea of exactly how dynamic and amazing it is to build a team with EXP and see how that passive income can accumulate. I mean, it is just amazing. So the other thing, and this is one of the things that really compelled me to move over to EXP is the stock. When you become an EXP agent, you have the opportunity to become an owner of the company by purchasing stock. You can make the option, and it is optional. You can take the option of having a portion of your commission come out to purchase stock in the company. And I think it's about 5%. And when you purchase that stock that way, you're getting it at a 10% discount, which I think is just incredible. So every time I have a closing, I get some EXP stock. I'm not thinking about it. It just happens, and I can log into my ShareWorks account and see how much stock I have and how much it's worth. And, the stock market is speculative. So it's going to go up, it's going to go down, and that's okay. You have to think long term. And like I was talking to a friend of mine and telling her about the stock. And when I first became an EXP agent, I think the stock was trading at like 100 and I don't know, 150, $160. And then it split at the beginning of this year. And when it split, I think it must have been about 70 or $80. And then it tumbled, and it has gradually been working its way back up. And, all of that is okay because, like I said, the stock market is up and down. It's just like real estate. Real estate values go up, real estate values go down, real estate values go back up. But just the idea of being able to purchase stock in the company, be an owner of the company, I just found that very, very appealing. And so that's another bonus. Another thing that EXP does, and I'm not sure if there are any other brokerages out there that are doing this, but they actually offer health insurance benefits. So they have partnered with a company, and for the life of me, I can't remember the name of it. But if you are like so many realtors who don't have insurance, you have an opportunity to get some insurance through EXP. And so that is another great benefit. So I think that you get my point. EXP is worth exploring. So if you have any questions about EXP, if you'd like to explore a little bit more in depth, I'd love to talk to you. So I am going to add my contact information to the description of this video. I will add Donell's information as well. And, just reach out to us. We would love to chat with you. We are not high pressure, push, push, push. You got to make a decision today. We are just here to share the EXP opportunity with you and to answer any questions that you might have. And if you decide that it's not for you, that is perfectly okay. If you decide it is for you, that is even better. So we look forward to hearing from you, answering any questions that you might have. And remember, we are here every Tuesday night at 8:30 p.m. Eastern Time for Realtor Life with Donell and Sharon. We will be back next week with episode 13. And I guess we'll talk about what we were supposed to talk about tonight, the due diligence period. So please feel free to share this video with any of your friends and family who are realtors, anyone who is considering a career in real estate. Our purpose in doing this is to really just be a source of information. We always say that, every time we think we've seen it all or we think we've heard it all, we realize that we haven't. And so the things that we are sharing with you each week are things that we have experienced personally or stories that we've heard from our realtor friends and colleagues. And we know that sometimes people are afraid to ask questions. Maybe they're uncertain about whether they're getting accurate information, and maybe they just feel like they need another resource. And That's what we seek to be, is a resource for some good, solid, practical information. We do not hold ourselves out as being gurus. We are just two realtors that are in the trenches each and every day, working to build our real estate empires. And, we just want to help other people, other agents get the information that they need so that they can be as successful as possible. So that is it for tonight. Thank you so much for tuning in, and we will see you next week for episode 13 of Realtor Life with Donell and Sharon. Until then, take care and have a great evening. Bye-bye.